How might an ICJ case reinforce efforts to codify gender apartheid? An ICJ case could establish a factual record of gender apartheid, highlighting the need for its formal codification. The prohibition of discrimination is a cornerstone of international law. However, unlike apartheid, which is recognized as a crime under international criminal law and defined as inhuman acts committed for the purpose of establishing and maintaining domination by one racial group of persons over any other racial group of persons and systematically oppressing them, the concept of gender apartheid is not yet codified. Gender apartheid builds on the existing legal definition of apartheid by including gender as a basis for apartheid. But because gender apartheid is not yet officially recognized as a crime under international law, international and domestic criminal courts cannot prosecute it. Accordingly, many Afghan women and advocates are calling for gender apartheid to be recognized as a crime against humanity, arguing that current laws addressing gender persecution fall short of capturing the specific intent and institutionalized nature of the Taliban systematic subjugation of women. While the ICJ is unlikely to rule on the idea of gender apartheid, which is not a codified concept under CEDAW, an ICJ case against Afghanistan could nevertheless play an important and complementary role in helping advance the campaign to codify gender apartheid. For example, the ICJ case could create an authoritative record of the Taliban's systematic gender-based oppression and domination, including the multiplicity of rights violations, documenting the reality of gender apartheid in practice. This record would provide concrete official findings by the world's highest court as to the severity and pervasiveness of gender-based discrimination in Afghanistan. Such a ruling could establish a legal precedent by recognizing the systematic nature of these violations, offering a strong foundation for advocating for the formal codification of gender apartheid as an international crime. Moreover, ICJ cases attract significant global attention. An ICJ case against Afghanistan would draw continued international focus to the plight of Afghan women and girls, thereby strengthening advocacy efforts for recognizing and codifying gender apartheid under international law. An ICJ case could also highlight the gaps in existing legal frameworks, underscoring the need for codifying gender apartheid to ensure comprehensive legal protection and accountability, particularly in the realm of international criminal law. This is underscored by the CEDAW Committee itself, who recently called for its codification to create full accountability for gender-based crimes. The codification of the crime of forced pregnancy offers a useful example of how human rights law can support the criminalization of serious violations. Initially recognized as a serious violation under international human rights law, forced pregnancy was not explicitly listed as an international crime. But the international trials of the atrocities in Bosnia and Rwanda brought the issue into sharp focus, leading countries in civil society to advocate successfully for its recognition as a crime against humanity and a war crime in the Rome Statute of the International Criminal Court. Similarly, an ICJ case could serve as a catalyst for recognizing gender apartheid as a crime, paving the way for more comprehensive protections for women and girls in Afghanistan and worldwide.